Divorce is one of the most financially complex events a person can face. The decisions made during this process can shape the next chapter of a life for decades. Welcome to Advisor in Your Corner, the podcast for individuals navigating the financial realities of divorce in California, and for the attorneys, mediators, therapists, and coaches who support them. Your host is Weinberger, a certified financial planner professional and certified divorce financial analyst, bringing clarity to the questions that matter the most to you without the jargon. This is Advisor in Your Corner.
There's a number I want you to sit with for a moment. After divorce, the average woman over 50 experiences a 45% decline in her standard of living. The average man experiences a 21% decline. That isn't a small gap. That's more than 2 times the financial impact, on average, falling on one side of the marriage. That number was published in the Journals of Gerontology a few years ago, and it's been confirmed and refined by subsequent research. It's the most important statistic in the entire field of divorce finance, and almost nobody hears about it until they're already inside the experience. If you are a woman in your 50s, 60s, or 70s who's contemplating divorce, going through divorce, or recently divorced, this is the statistic that should be shaping how you approach the process. Because in case after case I've seen, the difference between landing closer to the 21% number and landing at the 45% number is not luck. It's decisions made early with information. Today, we're going to walk through what I call the 45% cliff, why it exists, what's actually driving it underneath the headline number, and the specific settlement patterns that lock women into the lower outcome. We'll cover 6 things. First, where the number comes from and what it actually measures. Second, why the lower earning spouse in any marriage is structurally more exposed in divorce. Third, the lump sum trap, which is one of the most common ways women lose ground in settlements. Fourth, the marital home trap, which is the most emotionally loaded financial decision in any gray divorce. Fifth, the investment risk transfer that nobody warns you about. And sixth, the spousal support reality, which has changed meaningfully over the past decade. Let's get into it. The 45% figure comes from peer-reviewed research looking at how standard of living changes after divorce, with the comparison focused on women age 50 and older. The number is consistent with a broader body of research showing that women, on average, take a substantially harder financial hit from divorce than men do, and that the gap widens as the age at divorce increases. A few clarifications matter. The number is an average, not a fate. Some women come through divorce financially equivalent to where they were, or even better off. Some men experience drops of 40 or 50%. The number describes a population, not an individual. Standard of living in this context means the amount of post-tax income available to support a household, divided by the number of people in that household and adjusted for the lifestyle the family was living. A spouse who was living a comfortable upper middle class lifestyle and ends up with a budget that supports a modest middle class lifestyle has experienced a meaningful decline, even if their absolute income is unchanged on paper. The 45% number is the result of 2 things compounding. First, the lower earning spouse loses access to the higher earning spouse's income. Second, household expenses don't drop in proportion to household size. 2 people living separately need more than half of what 2 people living together needed. 2 homes, 2 utility bills, 2 insurance policies, 2 of nearly everything. Setting aside gender for a moment, the lower earning spouse in any marriage is structurally more exposed in divorce. The reasons are mechanical, not moral. The lower earning spouse has less ability to rebuild what they lose. If you earn $300,000 a year and your settlement leaves you with less than you expected, you have time and earning power to make it back. If you earn $50,000 a year or 0, the same shortfall is much harder to recover from. The lower earning spouse often has less negotiating power during the divorce itself. They may have less liquidity to fund legal fees. They may be more emotionally and financially dependent on settling quickly, even on unfavorable terms, just to be able to move forward. The lower earning spouse usually has less financial sophistication, not because they're less intelligent, but because the higher earning spouse has typically been the one paying closer attention to the investment accounts, the tax returns, and the long-term financial structure. Information asymmetry inside a marriage becomes a real problem at the moment of divorce. In most heterosexual marriages, especially among the demographic I work with in Los Angeles, the lower earning spouse is the wife. That's not a universal truth, and the dynamics I'm describing apply to any lower earning spouse, regardless of gender. But the pattern is statistically dominant, and it's the reason the 45% number falls where it falls. Now let's talk about the specific settlement patterns that drive the cliff. The first and most common is the lump sum trap. In many divorces, the lower earning spouse is offered the choice between ongoing spousal support payments and a one-time lump sum buyout. The lump sum is often presented as cleaner, simpler, more independent. No more financial entanglement with the former spouse. No more checks every month. A clean break. That framing is appealing, and in many cases, the lump sum genuinely is the better choice. But it carries a hidden risk that's rarely discussed openly at the negotiating table. The lump sum transfers all of the longevity risk and all of the investment risk to the receiving spouse. If you accept a lump sum, you have to make that money last for the rest of your life, through whatever investment markets you encounter, with whatever inflation we get, with whatever unexpected expenses arise. Names and identifying details have been changed for client privacy. Imagine a woman, call her Susan, 62 years old, married 34 years. Husband ran a successful business. The lump sum offer was substantial on its face, $4 million, presented as the equivalent of 20 years of spousal support at the rate she'd been used to. Susan was tempted. The idea of being financially independent of her former husband was deeply appealing. The work we did together was simply to model what that $4 million actually had to do across the rest of her life. Pay for her housing, her health care, her travel, her support of 2 adult children, her grandchildren, and her own retirement, with inflation, with market volatility, with the possibility she might live to 95. The number that came back was not 4 million. The number that came back was closer to 6 million, given realistic assumptions. Susan negotiated. The final settlement was not exactly 6, but it was meaningfully higher than 4. The work to understand the actual cost of her life going forward was what changed the outcome. If you're being offered a lump sum before accepting, the numbers should be run by a certified divorce financial analyst against multiple market and longevity scenarios. The difference between the right number and the wrong number is often well into 7 figures. The marital home is the second major pattern, and it deserves more attention than it usually gets. The instinct to keep the house is powerful. It's where the children grew up. It's the anchor of family stability. The school district, the friends, the neighborhood, the routines. For a parent who's about to face the disorientation of divorce, keeping the house feels like keeping a piece of solid ground. The financial reality is often that the house is too expensive to keep on a single income. The mortgage payment, the property taxes, the insurance, the maintenance, the utilities, all of it has to come out of the post-divorce income, which is usually substantially smaller than the household income that supported the house in the first place. There's also a structural problem in many divorce settlements. To keep the house, the lower earning spouse often has to give up an equivalent share of liquid assets, the retirement accounts, the investment accounts, the cash. So they end up with a house and very little else. 5 years later, when something needs replacing, when the roof goes, when a child needs college support, there's no liquidity. The house is the wealth, but the wealth is unspendable without selling. The cleanest framework I share with clients is this: decide on the lifestyle. Then decide on the assets that support the lifestyle. Then decide on whether keeping the house fits inside that picture. If keeping the house means the rest of the financial life doesn't work, the house is a luxury you can't afford, no matter how much it feels like a necessity. This is one of the conversations clients find hardest. It's also one of the most important. The third pattern is more subtle. It's what I call the investment risk transfer. In most marriages, especially among high net worth households, one spouse has been more active in managing the investment portfolio. They've been the one talking to the financial advisor. They've been the one watching the markets. They've been the one comfortable with risk. When the marriage ends and the assets are split, the less involved spouse suddenly inherits a portfolio they didn't build, with risk levels they didn't choose, in a market environment they may not fully understand. They're now responsible for managing it through their entire post-divorce life. That transition needs to be deliberate. The portfolio that was appropriate for a married couple in their accumulation years is often not appropriate for a divorced individual whose financial picture has fundamentally changed. The risk tolerance is different. The income needs are different. The time horizon is different. The tax picture is different. I've seen cases where a recently divorced spouse held the portfolio they were given for 2 or 3 years without making changes, partly out of inertia, partly out of unfamiliarity, and rode it through a market correction they didn't have the capacity to absorb. The 45% cliff can deepen substantially when this happens. A registered investment advisor, whether at Weinberger Asset Management or another firm of your choosing, should be reviewing the portfolio for fit with the new financial life, not just rolling it forward unchanged. The last topic is spousal support, and the realities here have changed meaningfully over the past decade. In California, where I work, courts have moved away from the assumption that spousal support is permanent or near permanent for long marriages. The trend is toward time-limited support, often calibrated to allow the lower-earning spouse a defined period to retrain, re-enter the workforce, or otherwise become self-sufficient. The specifics, the timelines, the formulas, all of that is a conversation for your family law attorney because the rules vary by state and the case law continues to evolve. What this means practically is that the lower-earning spouse, more than ever, needs a clear plan for what their income will look like once support ends. A plan that assumes support will continue forever is a plan that will likely fail. There are 2 more pieces of the puzzle worth naming before we close, because they show up in almost every gray divorce case, and they hit women hardest. The first is healthcare. If you are under 65, you are not yet on Medicare. If you've been covered under your spouse's employer health plan, that coverage typically ends at divorce. You can extend it through COBRA for up to 36 months, but COBRA is expensive, often $800 to $1,500 a month for a single person, depending on the plan. If you are 61 and divorcing, you may need to bridge 4 years of healthcare coverage on your own before Medicare kicks in. That is potentially $50,000 to $70,000 of premiums, plus deductibles and out-of-pocket costs that did not exist as a line item during the marriage. This is one of the items most often missed in gray divorce settlements. Couples focus on the assets, the home, the retirement accounts, the investment portfolios. They forget that the lower-earning spouse is about to face a meaningful new expense that did not exist before. Building healthcare bridge costs into the settlement, either as a lump sum offset or as part of spousal support, is something worth raising with your attorney during the settlement process. The second is Social Security. And there's a rule that applies specifically to divorced spouses that I want every woman in or near a gray divorce to know about. If you were married for at least 10 years and you do not remarry, you may be entitled to claim Social Security benefits based on your former spouse's earnings record, if their benefit is higher than yours. This applies even if your former spouse has remarried. It does not affect your former spouse's benefit at all. They will not even be notified. For the lower earning spouse in a long marriage, this can be meaningful. If you spent 15 or 20 years out of the workforce raising children, Your own Social Security benefit may be modest. Your former spouse's may be substantial. There's an important detail in the rule. The marriage has to have lasted at least 10 years. The specifics of how this applies in your situation are a conversation for the Social Security Administration, your family law attorney, and your financial advisor. The reason I'm mentioning it is that it gets missed entirely in many gray divorce conversations, and once the divorce is final, the people who could have raised it have moved on. The 45% cliff is not destiny. It's the average outcome when the typical decisions are made by the typical lower earning spouse with the typical advice. Every part of that sentence is changeable. Better information leads to different decisions. Different decisions lead to different outcomes. The women who come through divorce closest to even with their pre-divorce standard of living are not the ones who got lucky. They're the ones who insisted on understanding the numbers, refused to accept settlement structures they hadn't modeled, and took the time to build a financial plan that worked across the entire arc of their lives, not just the next 12 months. The cliff is real, but the cliff is not where you have to land. The work between the ages of 55 and 65, the work of understanding what your life actually costs and what you actually have, is the work that decides where on the spectrum your post-divorce financial life lands. 21% and 45% are both averages. Where you fall within and around them is largely a function of the choices you make and the team you make them with. If this episode has resonated with you, please share it. There are a lot of people out there who are about to face this transition or already in it who would benefit from hearing the cliff named clearly.
Thank you for listening to Advisor in Your Corner. If today's conversation raised questions about your own situation or a client's, Alex Weinberger and the team at Marriage Financial Solutions are available to help. They work directly with individuals navigating divorce and alongside the attorneys, mediators, therapists, and coaches who support them. Every engagement is handled with the discretion, rigor, and independence the moment calls for. To learn more or get in touch, visit marriagefinancial.com. If this podcast has been useful to you, please share it with someone who could benefit and subscribe wherever you listen. This has been Advisor in Your Corner. We'll see you next episode.
The information and opinions presented in this podcast, including the views of guests not affiliated with Marriage Financial Solutions, is for general informational and educational purposes only and should not be considered personalized financial, tax, or legal advice. Marriage Financial Solutions does not provide advice regarding securities or the advisability of investing in securities. Marriage Financial Solutions is affiliated with Weinberger Asset Management, an SEC-registered investment advisor, and may refer listeners to Weinberger Asset Management when investment advisory services are appropriate. However, individuals are not obligated to use the services of Weinberger Asset Management.